In this short video, I wish to provide you with an introduction on how to appear in court on your first court appearance. Let's assume, for sake of argument, that your client is charged with one count of common assault. Now, that is a charge which, since the Moynihan reforms in 2010, must be dealt with by way of hearing in the Magistrates Court if it's to be contested. So that, in other words, there's no election for it to be taken to a higher court. At the first appearance, the usual courtesy would be that you introduce yourself to the prosecutor and let the prosecutor know what you intend to do on that day. If you need to obtain a copy of the court brief and the alleged criminal history, then do so and ask for that at first instance. If it is a matter where the client has been given a notice to appear, rather than being put on bail through the watch house, then your client will most certainly need to be in attendance in person, because if the matter is to be adjourned, the magistrate is very likely to want to put the defendant on bail, which is essentially a promise to turn up again at the next hearing. So let's assume for a moment that the client is charged with common assault, the client wants to contest the matter, and the instructions are firm. The way it should work is that at first instance, if the matter is to be the subject of negotiations, it would be set down for a further mention to enable case conferencing to take place. Case conferencing is really a process of negotiation between prosecution and defence, and it's useful for a number of reasons that we'll go into in more depth later, but those reasons might be to convince prosecution to withdraw the charge completely, to change the charge from one of common assault to something else, for example, public nuisance, or it might be to negotiate various aspects of the trial generally. But let's assume that we don't want to go to case conferencing, we don't wish to engage in discussions or negotiations, which is not the preferred approach from the court's point of view. In some circumstances, it's appropriate. So your instructions are, we want to go straight to trial, we don't wish to negotiate. What do you do when you appear in court? Well, if you're not admitted as a solicitor, you will need to seek leave of the court to appear. What that means is that you need to ask for permission for the court, or from the court, to appear in that instance. You don't have a right of appearance automatically. My suggestion to you is that you should make contact with the court's associate, or the clerk of the court, and maybe even in a letter introduce yourself and perhaps have your supervising solicitor sign a certificate that you are familiar with court process and that you're familiar with the file. That way, when you go into court, you may have even received an indication in advance that the court is prepared to hear from you, even though you're not admitted, and grant you leave to appear. But if not, at least it will mean that the court is aware of who you are and why you're there, and in relation to which matter you're appearing. It gives you a head start, gives you a bit of credibility, rather than being asked or having to introduce yourself effectively from the bar table. If you're lucky, the presiding magistrate may even call you by name, which will provide you with some credibility. In any event, you're on your feet. What do you do? The first thing you should do, if the prosecutor hasn't already announced that it's in relation to the matter of blogs of course being your client, is you should alert the court that it is to do with the matter of blogs. So my preferred approach would be to do something like this. Your Honour, would you please take the matter of Joe blogs? That gives the magistrate a chance to dig out the file, and typically a busy magistrate may have many files surrounding him or her on a call-over day, call-over meaning a list of all the matters essentially on for that day. So once the magistrate has, you can see that the magistrate has a file in front of him or her, you can then proceed. So don't rush into it, just work in with the magistrate rather than trying to quickly say anything you have to say. So the magistrate now knows that it's a matter of blogs, has the file in front of him or her, and is ready to proceed. Now, the magistrate may say something like, Mr. X or Ms. X what is the current matter, or sorry, what is the current position on this matter, or you may start to talk. So play a little by ear, but essentially what you need to do is say something like this: Your Honour, in relation to the matter of logs, I take the charge of common assault as read, and I have instructions that this is a matter to be contested. I have instructions from my client that we do not wish to engage in case conferencing, and accordingly, if Your Honour is minded to do so, we ask that the matter be set down for hearing at first instance. If that is technically what should happen under the Moynihan provisions and the practice directions, and the matter should be listed for hearing not less than 7 weeks from the date of first mention, on the basis that prosecution are required to prepare a full brief of evidence and provide that to you within 5 weeks of the first mention, and not less than 2 weeks between provision of the material and the trial itself. So that gives you 2 weeks to read the material, read the evidence that they're going to present against your client, and take instructions accordingly. So, just in summary again, what we say is, Your Honour, would you please take the matter of blogs? My name is your name, Clark, and the employer of XYZ lawyers. I seek leave to appear in relation to this matter. I take the charge of common assault as read, and I have instructions to seek a date for hearing in this matter. The court will then take control of the proceedings. You may be invited specifically to ask for bail, although usually magistrates will assume that your client does want bail and will grant bail, usually on his or her own undertaking, simply a promise to turn up. Other magistrates may say, are you applying for bail? And the answer to the question is, yes, I am applying for bail. Thank you. So that's it in a nutshell. That's a basic introduction to first mention for a summary matter, that is a matter in the Magistrates Court that will be dealt with in the Magistrates Court, and a matter that's going straight to hearing. Thank you.